Good afternoon. I want to welcome you all to the final round of the closing argument competition. My name is Brian Boatwright, and I currently serve as the MAC president. I was asked by Dean Powers to welcome you all here. She unfortunately can't be here today as she had a doctor's appointment, but if I know her, she's watching on her phone right now on the live stream. I'm going to turn it over to our closing argument committee here in a second, but before I do, I just want to say how happy we are that everybody's here. Just 2 years ago, we had the final round for our class, and if I can remember right, I think there were 17 people here total. So it's been a priority of MAC over the past 2 years to continue to build outreach and interest in these closing argument competitions. All of the advocates that competed in here are the future of Mercer advocacy, so we're all happy you're here. But none of it would have been possible without 3 people, and that's Olivia Salter, Rich Morrison, and Joseph Oliver. They have put in countless hours in writing the problem, running this competition, getting judges, tabulating scores, and I just want to give them a big round of applause before we turn it over to them.
People of Mercer Law, welcome. My name is Joseph Oliver, and I'm the current MAC Arbitration Chair. Welcome to the main event. This is it. It's time. We started this competition 8 days ago with 54 competitors, fierce competition, and now we're down to 2, 1v1, mano y mano. Rose Baker and Madeline Winburn. They've put in countless hours, then they've showed tremendous early skill. So let's give these 2 individuals a round of applause. And let's keep that applause going for our 2 co-chairs, Olivia Salter and Rich Moore.
Hey everyone, I'm Olivia Salter, and I am one of the competition writers along with Rich Morrison. And really my job right now is just to say thank you. I want to thank all of y'all for being here, number 1. And I'd like to thank IT, and the Dean's Suite, and Andrea Williford for all of their help with the logistics of this competition. Without them, this wouldn't run well. I want to thank Dean Powers and Director Jeffrey Bloom for their help, and Brian's, of course, Brian Boatwright, for their help navigating our goals for this competition and what we wanted to get out of it. We wanted to have a great competition with a lot of people involved, and we wanted to see those advocacy skills. And we know that this 1-0 class certainly has a lot of them. And I want to thank our judges, who consist of attorneys and faculty members and students. Thank y'all so much, all of the judges who are here today, who have helped in the previous rounds of this competition, and the ones who are judging today. And lastly, but not least, I want to thank all of the people who competed in this, those 54 competitors. That is fierce competition, and for them to have made it that far and to just even sign up, that is a major feat. So thank y'all if you're here, and if you see them in the hallway, tell them congrats, because they really did a great job. And thank these 2 right here. We're going to have a great competition today. Thank y'all for being here.
Hey everybody, my name is Rich, one of the MAC Closing Argument competition writers this year. Before our advocates begin, we just want to give everyone some context as to where we are in the trial. So at this point in our fictional universe, opening statements have already been made. Every witness has been direct and cross-examined. All pretrial and mid-trial motions have been argued and resolved. Now we are left with closing arguments at the end of our trial. So the statement of the case that these advocates will be arguing reads as follows. Plaintiff, Mary Land, brings this lawsuit against defendant Randy Bloom for the wrongful death of her fiancé, Reed Washington, arising from an incident that occurred the night of March 26, 2024, on the Scott Key Bridge in the city of Floyd. While Reed was driving himself and plaintiff across the bridge, Randy the Boom Bloom drove a ferry boat used for Floyd's night cruises into one of the bridge's piers. The impact caused the entire bridge to collapse within seconds. Plaintiff witnessed Reed's death. Plaintiff alleges that defendant's actions were negligent and directly and proximately caused her fiancé, Reed Washington's death. Defendant asserts that driving the ferry boat into the Scott Key Bridge occurred as a result of the Floyd city government's negligent engineering of its ferry boats. The issue of whether Reed Washington's death was directly and proximately caused by defendant's actions will be determined by the trier of fact, the jury, in this trial. And now, everyone, we're going to go grab our judge and our jury, and we will begin.
All rise.
Good afternoon. Everybody can be seated. We are now calling the case of the estate of Maryland v. Randy Bloom. Counsel, are we prepared to proceed to closing arguments?
We are. Yes,
Okay.
Your Honor.
Counsel for the plaintiff. The floor is yours.
Your Honor, may I reserve 2 minutes of rebuttal time following the defendant's argument?
You may.
May it please the court. Your Honor, counsel, members of the jury, good afternoon. Again, my name is Rose Baker, and I represent the plaintiff in this case, Mary Land. What was supposed to be a fun night watching the fight of the century turned into tragedy. Mary watched as her lifeless fiancé was swept down the Wilkins River. How did she get here? On March 26, 2024, Mary Land and her fiancé, Reed Washington, were on the Scott Key Bridge going over the Wilkins River to watch a fight. At the same time, Randy Bloom was transporting one of the fighters, Blake Small. They were on the Wilkins River, headed towards the Scott Key Bridge. All of a sudden, Mary heard a loud boom, and before she knew it, her and her fiancé were nosediving into the Wilkins River. Reed's head banged against his steering wheel, causing him to lose a lot of blood. Mary couldn't swim, so Reed ripped the door off of his Jeep and hoisted her onto it, but there wasn't enough room for him. Blood gushing from his head, freezing water. He became unconscious. Eventually, they hit a tree, and Reed's hand slipped from Mary's. Randy Bloom didn't see the bridge before he hit it. What was he looking at? How did he not see a bridge on a river that he had traveled on plenty of times before? A caller to the City of Floyd Police Department saw it. The City of Floyd Traffic Control saw it and tried to warn him. Yet Randy Bloom blames everyone but himself. He says that the bridge was in bad shape. He says that it's the Floyd city government's fault. Can you do what Randy Bloom failed to do? Can you turn this boat around? Duty, breach, causation, harm. To succeed in this wrongful death case, the plaintiff must establish each element of negligence by a preponderance of the evidence. Negligence is the failure to do what a person of ordinary prudence would have done under the same or similar circumstances. Let's start with preponderance of the evidence. This means the greater weight of credible evidence presented here in this case. All you have to ask yourself is it more likely true than not true that if Randy Bloom wouldn't have crashed his ferry boat into the Scott Key Bridge, that we wouldn't all be here today, hearing this case about a young man who had his whole life ahead of him. Think of it as a scale, with weight over here and weight over here. When the scale starts to tip, this is preponderance of the evidence. First, we must ask, does the defendant owe a duty? This one's an easy one. The defendant, by his own admission, says that he owed a duty of care to Reed Washington that night. He, as a ferry boat captain, owes a duty to anyone he could have come into contact with, whether they're on the river or on the bridge. The standard of care for the defendant was that of a reasonable ferry boat captain under the same or similar circumstances. In his own statement, he said that all ferry boat captains are required to check all equipment before every ride and remain alert during the entire ride. Did the defendant breach that duty? Randy Bloom said it himself. Once all your equipment is on and up, just keep your eyes on the water and your hands on the wheel. But he didn't even do that, did he? He didn't check to see if he could communicate with traffic control. He ignored the flickering lights, and eyewitnesses say that he wasn't even looking up until seconds before crashing. He could have gotten another boat. He could have just not gone. Randy Bloom was not forced to captain the ferry boat that night. He chose to drive the boat knowing his lights weren't working properly. In his statement, he said that his exterior lights took some time to come on and that they flickered a bit throughout the first hour. He also said that his traffic control button was turned on, but he didn't check communications because he doesn't know a single ferry boat captain who communicates with traffic control. He said that captains rely on their instincts if something should go wrong. But say that all the lights go out and traffic control is trying to warn you that you're approaching a bridge. Wouldn't it have been helpful to hear traffic control's warnings? So, what would a reasonable ferry boat captain have done? If they knew their lights weren't working great, and they didn't even know if they could communicate with traffic control. Was this breach the direct and proximate cause? This should be a straight line, so let's walk backwards through the facts. Reed Washington is dead because he lost a lot of blood. He lost a lot of blood because his head hit his steering wheel. His head hit his steering wheel when his Jeep fell off into the river. His Jeep fell into the river when the bridge crumbled. And the bridge came crumbling down when Randy Bloom rammed his ferry boat into it. Reed Washington is dead because of Randy Bloom's negligence. So, what was the harm? Well, a family sits around their dinner table with one empty chair. There will never be a wedding. Reed will never teach Mary how to swim. He'll never have kids. When that bridge came crumbling down, so did any future Reed Washington had. Randy Bloom is the reason for all of this. He owed a duty of care to Reed Washington. He breached this duty by acting in a negligent manner, which directly and proximately caused Reed Washington's death. Randy Bloom's negligence on March 26, 2024 is the cause of this tragedy. The defendant raises an affirmative defense, which is basically when someone says, even if the plaintiff can prove A, B, and C, the defendant is not liable because of D. In other words, say all of this is true. Here's a justification or a reason why the defendant should not be held liable. The defendant bears the burden to prove this, but before you hear their argument, I want to give you something to think about. When children get in trouble for something they've done over and over again, sometimes they look for someone else to blame, someone to point their finger at. Here, we have a ferry boat captain who has crashed his boat twice before. In 2010, he crashed his boat into a dock with people on his boat. And in 2017, he crashed his boat into a dockside fuel station causing a fire. The tragedy that we're all here today to talk about is not a fluke. It's not the first time Randy Bloom has been the captain of a ferry boat that just so happened to crash. He's never truly been held liable before. So the question is, can you turn this boat around? Will Randy Bloom finally be held accountable for his actions? Soon, you will all receive a piece of paper, the jury verdict form. It will ask, did the negligence, if any, of the persons named below directly and proximately cause the death in question? You will answer yes or no for the two names listed. The first name is the defendant, Randy Bloom. And the second name is the Floyd City Government. The decision is yours. You must decide, will Randy Bloom finally be held liable, or will he be allowed to continue on with his life? I can assure you of one thing. The plaintiff, Mary Land, and the family of Reed Washington, their lives will never be the same.
Thank you, counsel. Counsel for the defendant. You may proceed.
For 50 years, the Scott Key Bridge stood as an integral part of this city's infrastructure. Yet beneath its grand appearance, hidden from the public eye, small cracks began to form. Insignificant at first, but gradually worsening over time. For years, the warnings were ignored, the maintenance was postponed, and the inevitable was delayed. But on March 26, 2024, it all came crashing down, and the negligent acts of the city of Floyd finally caught up with them. Now, the plaintiff would have you believe that one man, Randy Bloom, is solely responsible for this catastrophic collapse. But the evidence tells a different story. The evidence shows that Mr. Bloom was put in an impossible situation, navigating a ferry boat plagued by persistent mechanical issues under a bridge that had long been structurally compromised. And the city of Floyd, the very city that employed Mr. Bloom, turned a blind eye to these hazards. This is where the true negligence lies. In today's case, the plaintiff must prove by a preponderance of the evidence that Mr. Bloom's actions directly and proximately caused the death of Reed Washington. However, we have presented strong evidence in favor of our affirmative defense, that it wasn't Mr. Bloom's, but rather the city of Floyd's negligence that led to this horrific tragedy. If you find that the city's failure to maintain its boats and its bridge is what caused this collapse, then you cannot find Mr. Bloom reliable. For the law requires that liability be placed where it truly belongs. Let's review what we know. Exhibit number 7, the ferry boat inspection report from just a few days before the accident, shows that Floyd boat number 10, the very vessel that Mr. Bloom was captaining that night, had known issues. The bow's exterior lights flickered on and off, a problem noted but ultimately dismissed as not critical. And the button for the radio, it was so faulty that it had to be manually held up or down just to be able to speak or hear clearly. This was also an issue that the city was aware of, but they refused to fix, likely because the replacement button was going to be so expensive. Though Carter Byers, the inspector, passed this vessel for operation, he warned that these issues needed to be monitored. And this wasn't even the first time that these issues had been noted. But did the city take any action to repair them before sending Mr. Bloom out that night? No. They sent him out on a boat that they knew was flawed. Exhibit number 5, the article from the Mercer Sun, pulls back the curtain on the city's systemic neglect. Captains and experts alike had for years warned that these Floyd night cruise ferries were riddled with faulty equipment, including these flickering lights and these unreliable radios. But the city didn't care. They prioritized spectacle over safety, even planning a flashy fight night for Blake Small, complete with fireworks on that very boat. Profit over people. That is the city's pattern. Mr. Bloom did not design that boat. He did not skip its repairs. He did his pre-ride checks as always, and he trusted the city's clearance to operate. And what about the Scott Key Bridge? Mr. Bloom testified that he had previously noted cracks underneath the bridge's piers, visible signs of decay that the city simply ignored. Even Blake Small commented on how he too had previously noticed that the underside of the bridge looked, quote, rather rough, end quote, despite the fact that the top appeared to be in pristine condition. But this just falls right into the city's pattern of prioritizing spectacle over safety, doesn't it? Polishing the top of the bridge while allowing its foundation to crumble. The fact is, Mr. Bloom did not weaken that bridge's foundation. He did not allow it to decay. The city of Floyd did. And on March 26, that decay became strikingly evident when Mr. Bloom's ferry boat merely scraped the side of the bridge. Not a crash, just a graze. And the whole thing came crashing down. You heard testimony that a structurally sound bridge would not have collapsed from just that. But this one did, because of the city's failure to properly maintain it. Now let's walk through the events of that tragic night. Blake Small, a passenger on the ferry boat that night, testified that he saw Mr. Bloom trying to concentrate on something with graphs and charts, likely his navigational system or his radio, while Mr. Small was blaring music over the ship's malfunctioning speakers. The 911 call transcript with Melinda Hurley confirms that the boat's lights were flickering on and off, making it incredibly difficult for Mr. Bloom to be able to properly see his surroundings. And then, just before the crash, the lights went out entirely. The City of Floyd traffic control transcript further shows that Mr. Bloom was struggling with a malfunctioning communication system, preventing him from receiving the critical warnings from Operator Rebuttal. By the time he saw how close he was to that bridge, it was too late. Now, does this sound like the reckless actions of an incompetent ferryboat captain to you? Or does this sound like a man caught in a deadly trap, handed a ticking time bomb by a city who refused to fix its failing infrastructure? The plaintiff wants to paint Randy Bloom as careless, distracted, negligent. They want you to believe that he alone is responsible for the events of that night. But the evidence simply does not support this claim. Attorney Baker asserts that Mr. Bloom breached his duty that night, but we have presented clear evidence to the contrary. Wade Oliver, a maritime expert with over 22 years of experience, concluded in Exhibit number 6 that Mr. Bloom upheld his standard of care that night. He didn't breach his duty. He did what any reasonable captain could with what he had. But more than that, Mr. Oliver actually spoke very highly of Mr. Bloom, saying that he consistently demonstrated a strong level of skill, caution, and respect for safety protocols throughout his entire career. This wasn't some novice captain that we were dealing with here. Mr. Bloom has been publicly recognized and awarded for his skill and his professionalism. And on that night, he relied on his 15 years of experience, his instincts, and the city's assurance that that boat was seaworthy. He was merely doing his job, following the orders of his employer. He had no control over whether that boat's lights worked. He had no authority to make repairs to the communication system, and he had no duty to inspect or reinforce the Scott Key Bridge. But the city of Floyd did. They had a duty, a stipulated duty to Reed, Washington, and they breached that duty by sending out a ferry boat with known issues under a bridge that they knew was failing. That breach caused the collapse, ultimately ending in the tragic death of Reed, Washington. Duty, breach, cause, harm. Members of the jury, you've heard the evidence, you've seen the reports, and now you must decide. If you find that the city's negligence in failing to maintain its bridge and its boats is what caused this collapse, then you cannot find Mr. Bloom responsible. For justice does not punish a man for the failures of a system that he cannot control, but rather it holds accountable those who prioritize profit over the very people that it's supposed to protect. Those who could have acted, but didn't. The scale is in favor of the defendant today. And we ask that you return a verdict in favor of Randy Bloom, because the evidence tells the truth. This tragedy began and ended with the city of Floyd. Thank you.
Thank you, counsel. Counsel for plaintiff to the rebuttal.
Randy Bloom was not handed a ticking time bomb. He was the ticking time bomb. As you heard me say, he's crashed his boat twice before, once in 2010 and once in 2017. And now, we're here today for what? Once again, a crash caused by Randy Bloom. From the time that he figured out something was wrong with the ferry boat to the time that Reed Washington died, did he have opportunities to make different choices? Could he have made different choices that could have led to a different outcome? Now, something that the defense failed to tell you was that Wade Oliver is a friend of the defendant, Randy Bloom. Wade Oliver talks very highly of Randy Bloom, but that's what friends are for. From the time he figured out something was wrong to the time of Reed Washington's death, he could have made a different choice. The Floyd city government was not driving the boat that night. Randy Bloom was driving the boat that night. Members of the jury, I ask that you find Randy Bloom, the defendant, liable.
Thank you, counsel. So at this time, the members of our jury are going to go back and deliberate, and we will stand in recess for just a few moments and come back when we're done.
I messed up the first time. I said, what?
Yeah, you're done. Thank you.
So, before we get to our announcement of the winner, we are just going to have our jurors introduce themselves and give a little bit of quick feedback to both of the competitors. And so I think we can start with Mr. Lee down at the end.
Thank you. My name is Walker Lee. I am an alumni of Mercer and this program. I'm also a mock trial coach for this program and the arbitration coach. So this is my part-time job. But I practice here in Macon. I do government liability work, defense. So typically I'd be defending City of Floyd. Couple of things. Ms. Baker, you did a really good job on your rebuttal. It's always good to point out some of the facts that the defense likes to sneak out. So it's always good to bring that back in. A couple of things that I think I would work on, especially for your side, because you have the main burden here, is try to explain your law a little bit clearer. You know, I mean, jurors really know what a duty and breach is. It's kind of hit or miss. And then Winburn. You did a really good job with the exhibits, which I liked. It's always good to remind the jury of the evidence that they would have seen in trial. One of the things that I think would be helpful is at the end, you asked us to find in favor of Randy Bloom, but I think it would be really, really good to use the verdict form and just say find him not liable. So that's the only thing I have. So y'all did a really good job. Y'all should be proud of yourself. So.
That was quick. I'm Addison Gant. I'm an assistant federal defender here in Macon, also an alumni of Mercer. I did do advocacy when I was here, but it wasn't mock. Now I am a mock coach, and I'm taking over the public defender clinic next year. So I want to say, first of all, everybody did fantastic. So a lot of what we have to say is really just nitpicky stuff. Rose, I think just a little bit, you got a little bit nervous to start with. You had to set up some stuff. Have it set up beforehand. And there was a moment when you had to go back and look at your notes, and that happens. Sometimes a way to kind of play it off is to go over and say, I want to make sure I get this just right, and go look at it, and then that can kind of make it a little bit less awkward as opposed to being like, oh crap, what was I supposed to say? Let me go look at it. Madeline, you had really great movement with your hands, really good. There were times though when you weren't moving your hands and you had them just down by your side. If that's natural for you, keep doing that. It just kind of looks a little bit unnatural and like like the Ricky Bobby, what do I do with my hands, right? So there was a time when you did get them up around your waist and have them there whenever you weren't using them. And that's a better place to have them as opposed, because it's just not natural. You don't talk to somebody and they have their like toy soldier hands down beside them. So just have them and be more natural, because when you were moving your hands, you had really great movement and it really helped with your persuasion and your argument. So continue that kind of stuff. And just to both of you, just really good job. You're already better than I ever was. So yes, great job.
My name is Rebecca Harden. I'm also an alum of the mock trial program, as well as Mercer. Obviously, I am a mock trial coach now. So we are here quite a bit at the law school. I know how nerve-wracking this is. I remember how nerve-wracking this is. So both of you did a really good job of, if you were nervous, I could not tell. I could not hear it in your voice. I know there are so many people here. There are the 14 of us, so I know it's nerve-wracking. So really good job. Let's see. Rose, you were so confident, great presence, great eye contact with all of us. I know that's hard to do. Sometimes it's easier for people to just look right over our heads, and you didn't even do that. I loved your explanation of direct causation towards the end. That was probably one of my favorite lines. Madeline, let's see. You're very fun to watch. You really are fun to watch. I also really loved your closing paragraph. It was very powerful, as Mr. Lee would say. So seriously, y'all deserve to be here, so congratulations.
Hi, ladies. Let me start by saying both of you did fantastic. I was very, very impressed. My name is Taylor Wilson. I graduated here from Mercer in 2021. I also was on a mock trial team. However, that was the year COVID completely obliterated our country, and our competition was canceled right before we got on the plane. So we practiced, I use it now, so I won't say did not get a chance to see the inside of the competition. I lead the Peach and Crawford offices for the district attorney's office. We serve both all of Bibb County, Peach County, and Crawford County. So very recently, as of last week, I now run 2 offices, Peach and Crawford. I'll start with you, Rose. I absolutely loved you working backwards. I thought that was amazing. A lot of stories make sense backwards. And what you did was great. I really enjoyed that. What I would say as far as feedback, slowing down a little. You had some opportunities where you could have given us a little more emotion in what you were saying. The content of what you were saying was excellent. I would have just wanted a little bit more emotion. Something that my mock trial coach told me and something I carried with me. This is about telling a story. And your jurors, a lot of times, are going to be half asleep in real life, right? It has to be juicy, and people fall for the juice. You can be saying a whole lot of nothing, but if you say it in a very compelling way, they're going to be locked in. But I thought you did a great job, especially in your rebuttal. You came back and used something that she said right after she said it. I was like, oh, chef's kiss. So I thought you did a really great job. Miss Madeline, you are an amazing storyteller, my God. You got up here and it was the raw emotion. I was locked in almost immediately. I thought you also did a good job of pointing out or using some of the direct words that she used in her argument. I thought you did a really good job of that. I used to be a defense attorney before I was a prosecutor, and this is something that I would encourage you to do. Own your bad facts. You had me, and then you started saying some things. I was like, I don't know. You never want to lose credibility as being on defense, right? You got to jump on your bad facts and then figure out how to make them good facts. Because you knew she was going to get up there and say that was his friend. And that was an opportunity for you to beat her to the punch, right? Soften the blow. But I thought you did an absolute amazing job in telling the story, keeping us captivated. The only other feedback I had for you was the hands kind of at your side. You were doing such a good job using them when you started, so it immediately made me notice when they went to your side. But great job to both of you.
I'll echo the praise to both of you. I know this is it's a tough competition, and by making it this far, it really speaks to the amount of work you put in, and I'm sure that will pay dividends for your mock trial career here at the school and your trial career maybe in your actual career. I'm Jordan Josie. I'm a law grad here. I'm a personal injury trial lawyer. I did not do mock trial here. I did the moot court, but I also now coach the negotiations teams. And I saw really great advocacy on both sides. Start with you, Rose. You've heard this now, but your rebuttal was very punchy and direct, and you seized on a mistake by the failure to get out ahead of the conflict of interest, kind of personal connection of the defense expert. And that's something in real trial, the jury goes, and I see, that's like an aha moment. So good job on doing that. And again, your rebuttal doesn't have to be long, it just has to be punchy. So I thought that was the strongest part of your case, I think, was your rebuttal, which is great because you have to do it on the fly. So that means you had the instinct to kind of hit that. Madeline, I would have thought that you probably have some kind of theater acting background. Because you have very good command, and you are a very captivating storyteller. So congratulations to you both.
Well, I'm Virginia Josie, and I am a proud Mercer graduate. I also teach advanced litigation drafting here at the law school, formerly a mock trial coach, and I was privileged to be MAC president and competed as a finalist like you two. And of course, all my fellow jurists are going to talk about how exceptional both of you were, because incredible work. I mean, outstanding. I'm always impressed how this gets better every year. I think everyone can agree to that. My encouragement for you both would be you both have such strong skill sets, and they're both in very different ways. So I was privileged to be co-chair with my finalists for the rest of my advocacy career. So we were tasked and encouraged to borrow from each other's strengths. And I think that you both have such incredible personality and just commanding presence that I think that you can borrow from each other in so many ways. So I hope that you're looking at each other and recognizing your strengths and use those to propel your career even more than you already have. So congratulations on being here. I'm very excited to see the success that you both have.
We'll start back over there. I'll go at the end.
Okay. Hi, my name is Grace Martin. I am a partner here at Nolan Law Firm. I did not go to Mercer, but I graduated from the University of Georgia School of Law in 2018 and moved back down here. So I'm from Macon, born and raised. I will echo what everyone said. I think both of y'all did an absolutely incredible job. Madeline, it is clear that you have some kind of theater background, your use of expression, and even just your eyes, right? I could see what you wanted to say with just your eyes, and I thought that was really, really impressive. Rose, I thought, again, like everyone else, your rebuttal was incredible. I think taking the ticking time bomb and turning that around was just, I mean, absolutely great. I thought you explained the elements very well. And the request for the verdict form, I thought was fantastic. I mean, I really just think that both of y'all did great. I would echo, of course, the hands for you, Madeline, just a little bit of a thing. But when you did use them, you used them very effectively. And I think that you used your hands and your facial expressions as well. So, great job.
Well, my name is Willie Sizemore. I am a graduate, and I was on mock trial, and I coached with Walker and Addison this semester and enjoyed it. But before I begin, I'm an attorney at James Bates, Brennan Gruber in Athens. But before I begin, I just think that we should give you both a round of applause. Y'all have got And everyone has stolen my feedback, and I am positive, based on my experiences, you will get meticulous feedback going forward. So if it's okay with everyone, I'd like to yield my time to you all. I'd like to know more about you, so if you could just introduce yourself and where you're from, and if you have somebody you'd like to thank for helping you so far. If that's okay with everyone, I'd like to know more about you.
I'll be quick.
Okay.
Okay, so my name's Rose Baker, and everybody I have to thank is those people right there. Raise your hand. They're the best, and I love them, and I have everything to give to them. I'm an only child. I know everybody, what you just thought, you said she's spoiled. No. They're the best. They've given me more than I could dream of, and that's what I have to thank. So.
And where are you from?
I'm from Twin City, Georgia. Y'all probably don't know where that is. It's a one red light town. It's near Statesboro.
Okay.
Hi, I'm Madeline Winburn. I'm also from a town that you might not know in southwest Georgia called Bainbridge. It's a little bit bigger than one red light, but and I do have theater experience for this. If you asked that, my whole family's watching through that camera right there, and my husband's back there in the middle.
Well, it's great to watch y'all, and I appreciate y'all doing a great job.
That's a tough follow-up. My name is Josh Gregory. I practice civil litigation in Atlanta. I am a Mercer grad and had the opportunity to compete in this competition. Didn't make it quite as far as you guys, so you can already say you're better than me. But anyways, with both of you, I thought both of you were really good competitors. I'm not going to say anything substantive because when you start working with Katie Powers and Jeff Bloom, they'll get into that. But Rose, I thought you came out confident right at the beginning. Your eye contact was really good, and I think your confidence showed me that you really didn't need your notes at any point. I didn't think you necessarily needed to look at them, but sometimes you get caught up in the moment, things like that. But just, lean in on that confidence a little bit more. For Madeline, echo what everybody said about the theater experience. I could tell that it seemed like you either have theater experience or mock trial experience previously, because you seemed very comfortable in the courtroom. Yeah, pretty much everybody took what I was gonna say, and so that's pretty much it. But yeah, the Mercer advocacy looks like the future looks bright, and it's good to see you guys compete. So, thank you.
Hi, my name is Lauren James. I graduated from Mercer in 2021, and I competed in mock when I was at Mercer, and then I've never left. I've come back to coach every single semester, and I just adore it so much, so it's wonderful to see. Like I was saying, the future is very bright. So I think both of you did a great job on your presentation. I really wanted to listen to both of you and to hear the arguments that you were going to make. One thing I think both of you can improve on is really connecting the evidence to the elements a little bit more. How I like to describe it is your elements are like a box. And so you're going to put pieces of evidence in that box, and you're going to tell the jury exactly which evidence goes in those boxes. And I think there were times you each did well at doing that, and then there were times you could improve a little bit more. Like specifically, Rose, your causation argument, beautiful. As a juror, I didn't have to think at all after hearing your causation, and that's what you want. You want the jury to go back and think, yeah, I'm convinced 100%, I have no questions after what I just heard. And then Madeline, with your breach, I also thought that was really well done. And so, yeah, great job on presentation, but in the future, maybe just try to connect those evidence more to the elements.
My name is Frank Gaddy. I graduated with Virginia and Jordan here from Mercer 2016. I'm a partner at Martin Snow here in Macon. I'm the director of the Plaintiffs in Corporate Practice and Litigation Practice. I thought y'all both did an absolutely amazing job. It was fun to watch both of you. Rose, I really enjoyed your storytelling. You came out with a quip about, can you turn this boat around? I thought that was so witty. That was such a great line. I think you did really well with that. You came out with a lot of heat in the second round, or in your rebuttal. I would have loved to see that from the start, but I understand completely. You're in a room full of people, there's nerves, everything's going on. But you did an absolutely amazing job. I think potentially, if you wanted to, you could have attacked the friend aspect in your first go around. That way, when she brings it up, it's almost like you take the wind out of the sails already, and it hurts her argument. So you always want to have her on the defensive. But I thought you did an incredible job, and you should be really proud of yourself, and your parents should be really proud of you too. Madeline, you did a great job. You did an amazing job with your expressions, and clearly that's the theater. I was also forced through theater when I was a kid, and I'm a better trial lawyer for it. But you did little things with your expressions, with your eye movement, with the shrugging of your face, and you did some things at a time when most people aren't going to be looking at you, when it was her case. You're making reactions from the table. Oftentimes the jury is not just looking at who's talking, but they're looking at the whole room. And so when you gave those reactions, it was perfect and it was timely, and it wasn't anything offensive, but it was, you kind of shrugged up a little bit, and it makes me question what she's saying. And so you did a really good job on those subtleties. You had a couple really great quips as well. I think profit over people is amazing. I've used that personally in closing arguments in actual cases. I thought that was great. Spectacle over safety. You had a great command of the verbiage you were using, of your movements. I did notice the hand thing. I call that Toy Story arms, because Woody from Toy Story doesn't move his arms when he walks. And it was literally just like one time that I noticed it, but I think it did kind of jump out. But that's such an easy fix. And again, that falls under nervousness, but I think y'all both did an amazing job, and congratulations to you both.
Hi, my name is Joshua Wright. I'm a 2L here at Mercer Law. I'm a mock trial team member of the Mercer Advocacy Council, and I won this last year, and so I know what boat y'all are in, and you're probably tired and want to take a nap, but I still hope you join us tonight at Fall Line, everyone. But I think we've heard great commentary from people that are much more qualified to give y'all comments than me. So I'll just give you a compliment. I loved your rebuttal, and I loved your use of pithy phrases in your presentation as well. I would be honored to work with either of y'all on mock, and just so proud of y'all. So great job today.
I'm Madison. I'm a 3L here, also on the mock trial team, and I won my 1L year, so 2 years ago. I guess that's what qualifies us. But I'm gonna second what Josh said. Everyone's kind of covered a lot. You guys were both incredible. I was so impressed. You should be really proud of yourselves, and you guys are gonna make great advocates.
Well, one of the great things in serving as dean is you get to see the growth of everybody at the law school. And I do want to do a quick shout out to the jury, many of whom were my students who now are distinguished practitioners. So thank you for making me feel old. Appreciate you. I can tell that you all have really embraced what this challenge is with the closing argument. You spent a lot of time really thinking about the facts, really thinking about the law, and not just understanding the substance, but how do you use the presentation to further what the goals are of the closing argument. And I know from the first round to this one, you have really adapted and changed, and you will continue to do that. Both of you had a couple of wobbles throughout, but what I really thought was impressive is you kept with it, right? I could see on your faces sometimes that you said something and you were like, I want to take that back. But you just kept with it, right? You had the confidence in the hard work that you had put in, that you really knew what you were doing. And it was just a delight to be here in the final round. So I really appreciate both of you participating, and I look forward to the continued competitions that you will be doing in the future.
So, my name is Jeff Bloom, for those of you that don't know me. You can call me Captain, I guess, now. So I am the Director of Advocacy here at Mercer, along with Dean Katie Powers. I run the Mercer Advocacy Program, and one of the things that has become apparent is that just being a finalist at the closing argument competition is not only an incredible accomplishment in and of itself, but it's also predictive of a great future advocacy career. The people who have appeared as finalists in this competition have gone on to win Best Advocate in the entire nation at the National Trial Competition. This is just in the last several years alone. Willie Sizemore, I'll shout out, was a finalist at Top Gun, which is far and away the hardest trial competition in the country. Only the best 16 advocates in the nation are even invited to it in the first place, and the finalists have won a whole host of competitions, national championships. And so I hope that you all, I'm confident that you all will continue that great legacy of success. But I also know we have a lot of other 1Ls who competed this year. And Josh Gregory said something that was very important, which he didn't go as far as you folks in this competition. And yet Josh was a member of an incredibly successful and accoladed final national trial team for years. Right now we have a couple advocates. I'm not going to shout out everybody in this room because you guys are all wonderful, but Olivia Salter, who is the co-chair of this competition, she's universally considered to be one of the best 2 or 3 or 4 or 5 advocates in the entire nation out of thousands and thousands of people. Same with Brian Boatwright. How far did you guys go in this competition?
Sweet 16. Top 32.
So the point that I wanted to make to pretty much everybody is that even though being a finalist is predictive of very good things for your future, that many members of our program who are incredibly successful competed and did not make it here. You all are not yet trained, and you're about to get a lot of training, whether you like it or not. And so we're looking forward to working with a whole new set of students. So, without further ado, first off, congratulations once again to both of you. It really is a wonderful accomplishment to not have any help to do this. I could not have done this when I was in law school, and certainly was not as good as you, even when I was in my 6th or 7th year as a real trial attorney. But without further ado, the winner of our competition is Madeline Winburn. Been given no instructions on what's next, so I guess we are all released. Congratulations, guys. Thanks for showing up. Yep.